Welcome back to Haystack Help Radio. My name is Scott Watley. Our number is 303-477-5600. We appreciate you joining us this afternoon, and we're going to go right to the phones and to Bonnie Bowles. Bonnie, how are you?
Good, Scott. How are you?
I am wonderful, thank you, and I hope you have a great weekend this weekend.
Thank you.
And again, thanks for joining us. And, ever since I met you several months ago and started thinking about wills and all, I had no idea how many different types of wills are really out there. Mm-hmm. And so I wanted to go over some that I found and just trying to get explanations. And again, we've talked about it every time Bonnie's on. The large percentage of us out there really don't have anything down on paper. And so this is something that Bonnie can help you with. Her website is willsandwellness.com. And her number is 303-881-3609. 303-881-3609, and she can help you with any of this. So let's go through, first of all, just, definition of just a will and what its purpose is, and then we'll get to some of these specific types.
All right, great question. So a will or last will and testament is kind of the classic estate planning document. It's the one that says who gets what, ultimately. So everyone has an estate of some sort, whether it's just a watch that was passed down to you from your grandfather, up to, homes, bank accounts, investment accounts, and all that. And a will just basically says who gets what out of the property that is subject to the will. And that may sound kind of confusing, but what I mean by that is anything you leave behind that doesn't have a surviving owner who's entitled to everything, like a joint bank account or something, or that doesn't have a beneficiary designation, is subject to whatever your will says. That's kind of the most basic definition.
Okay, good. Now, let's go through, and again, I've found these, and I'm sure none of these will catch you off guard, but let's talk about an attested will.
So an attested will, well, let me just back up and say, generally speaking, in Colorado, a will must be in writing to be valid at all. But what is a writing? And do you need witnesses? Do you need notaries? How does all that work? So that's where an attested will comes in. That is a will in writing, attested to by two witnesses. So not only did the testator, the one who makes the will, sign it, but two witnesses signed it as well. So when you hear that something is an attested will, that means two witnesses have signed it. That gets into some other questions, such as did the witnesses see the testator sign it? How did the testator use a signature or just an X mark or a smiley face for his signature? But generally speaking, if we're not talking about those issues, an attested will is signed by the testator and two witnesses. One step above that to make a will even more valid, and I don't know if that's really the right phrase, more valid, but more accepted by a probate court, is something called a self-proved will. So back in the day when wills were being probated and there were no notaries or anything, or at least that wasn't a common practice with wills, those two witnesses who signed a will would have to come in and testify in court and say, yes, I saw the testator sign that will, and that is my signature right there on the will. But you can imagine a lot of logistical issues with that, especially if a will is very old. So the law started providing, throughout the United States, each state started providing a mechanism to avoid that, which is one step up from the attested will. Not only did the two witnesses sign it, but the witnesses and the testator signed it, all three, in front of a notary who also signed it, which the idea there was to make sure those witnesses didn't have to necessarily come into court to prove the will 20, 30, 40 years down the road.
Okay. And what about a conditional will?
Well, a conditional will is an interesting will. I mean, that's a will where you say, well, if this, then this, but if not this, then that. That's where it might get a little bit interesting depending on what the condition is. If it's something very clear, such as if I die on a Tuesday, this happens, that's easy. If you say, if I die of cancer, that one might be easy, but might not. But so the idea that a condition is, it's basically you're stating if this and this, but if not, then that.
Okay, that makes sense.
Yeah.
And then what about a joint will?
Well, joint wills are interesting. Joint wills are used where two people make a will together. And so when one of them passes on, the idea is really that when the first does pass, that they can know that ultimately what they leave behind will go ultimately after the survivor passes to whoever the couple jointly agreed on. It's something that is common, at least when I see it in practice, between couples where the spouses have been married previously, and they want to make sure that their surviving spouse is taken care of because that's their spouse now, but also that kids from a prior marriage or relationship are ultimately taken care of and not disinherited. So that's the idea behind a joint will. There are some downsides to a joint will because you're relying on the fact that, and this goes back to my very first comment, that there will be property subject to your will at all. But if you own property as joint tenants, for example, your will doesn't control that. The other joint surviving owner would just become 100% owner of property. Or if you're a joint owner on a bank account, let's say if it's a surviving wife and the husband who's passed away has kids from a prior marriage, if she adds her own kids to the bank account and she passes away and they're surviving owners, this joint will the husband made before he died won't even control that bank account. So a joint will, the idea is to make sure that ultimately your side of the family inherits from you, but there's a few downsides because you want to make sure property is titled correctly.
Okay. And then one we hear a lot about is a living will.
Okay, so a living will is actually not a will in the traditional sense of the word. It's not a document that says who gets what and kind of puts parameters on how that happens. A living will is designed for you to specify what happens to you if you're on life support. The idea being that basically we're going to presume if you're on life support, you're unable to communicate your wishes and what you'd want in those circumstances. Now, if you have a medical power of attorney, which is where you say who's in charge of your medical decisions, but you don't have a living will, your medical power of attorney has to decide when to pull the plug, if that's the question you're being faced with. So that would be a burden on your medical power of attorney to decide, and that's a little bit. It gets a little bit tricky when you might have other family members who are chiming in saying, no, we don't want to pull the plug yet. You shouldn't do that. Things get really tricky and uncertain. And so the idea with the living will is that you're expressing ahead of time. You're telling your medical power of attorney and your doctors, if this is what's going on, if I'm terminally ill, if I'm irreversible, if I'm unconscious, if I'm only hanging on by life support, I want you to pull the plug after, say, 7 days. So that's the idea behind the living will. It has nothing really to do with property. It's really all about life support.
Okay. I wonder who came up with that term, pulling the plug.
Yeah, I don't know. You get colloquially called pulling the plug.
Yeah, I know. It's like, man, somebody should have thought of a better way to say that.
Yeah.
Now, there was also something I read about, and it was called a mirror will.
So a mirror will is similar to a joint will, sometimes also called a mutual will.
Okay.
And that's the same notion. It's where you've got two people, normally a husband and wife, where they're wanting to ultimately have the same end goal, but don't want to leave it up to chance as to who passes away first. So a joint will is one document for two people, whereas a mirror will and really a mutual will, they're basically the same. It's two different documents, but they mirror image each other, saying, well, if I'm the husband, I leave everything to the wife and then to our 6 combined children. And the wife would say, I leave everything to the husband, or if he's not there, to our 6 combined children. So the ultimate distribution is the same, but it's 2 separate will documents. Now, the downside there is that when the first person passes away, the second one can go update their will if they want and totally change the ultimate beneficiaries. Now, then it would be a question of, were they under some sort of contract or agreement to keep the will in place? Things get a little bit tricky there if you're the side of the family who's trying to be cut out by a future spouse.
Right. Now, is there any such thing as a will that's just, orally and then there's nothing written?
There is. Oral wills exist under some states' laws. Another way that those are called is non-cupative. It's a weird word, but it basically means oral, spoken, and not written. And in Colorado, those are not recognized. One of the basic requirements for a will in Colorado is for it to be in writing. So while oral wills are permitted in other states, it's not permitted in Colorado. And in any event, no matter where you are, you really don't want to rely on an oral will if you can help it. Now, along those lines, there have been, and I studied in law school, a number of cases where, someone was on their deathbed unexpectedly, and they spoke their wishes, and that would be an oral will. And even if that's not valid in your state, at least you've expressed your wishes, and if there's a witness, they could testify in a probate court as to what you wanted, and that may carry some weight, but it depends on the circumstances. Now, in a case that I read about recently is really interesting. A gentleman who was a farmer, I think back in the 1920s, was farming out on his land, and he ended up falling off his tractor and getting run over, and he was gravely injured. And he was trapped under the tractor, and he actually took a pocket knife and scratched his will onto the bumper of the tractor. And it said something basic, to my wife and something else about his kids. And that bumper of the tractor was literally taken to the court and submitted into evidence as his will.
Wow.
Now, obviously, there were not witnesses to that will, so it's not oral, but we're not at the higher level of proof, as we talked about earlier, in terms of an attested will or self-proved will. So a will that's written, even with a pocket knife on the bumper of a tractor, is a written will. Those are called holographic wills, means it's written but not otherwise witnessed by anybody in terms of a witness signing. That's a holographic will. And in Colorado, those are permissible. Now, you still have to go through some pretty stringent steps to prove that is the last will of the person who died, but that did count in that case.
Okay. And then what about a one I read about was called a pour-over will?
So a pour-over will is a will that ties in a trust. So there's kind of two ways you can have a trust. And what is a trust versus a will? A trust is a document that, generally speaking, lasts longer than what a will is designed to do. A will is pretty much a snapshot. When you pass away, who gets what? At that moment, whoever's alive, whoever may have predeceased you, let's figure out what the family tree looks like. Who do you want to get what? And then that's really it. The will has done its job. Whereas a trust, it says, okay, when I pass away, this is who I want to get what. But if we've got these different scenarios going on, maybe one of your beneficiaries is under 25, or one is a special needs beneficiary, or maybe you have estate tax issues, or something like that. A trust is more like a movie where it starts when you pass away, and then you can direct it based on the instructions you leave behind in a trust, and you can direct it over time. So a pour-over will basically says to the world, I have a trust that exists. It's a separate document from my will, and anything that I leave behind, I leave it to my will. The idea being that you ultimately distribute everything from your will to your trust that you've created as a standalone document to be governed by the trust terms, and there's no probate of a trust when it's a standalone trust and you've got the will that's a pour-over will.
Okay.
That should be contrasted with another type of will called a testamentary trust will, where literally the will and the trust document are one and the same. So the will ends up being, let's say a will would have been 4 pages as a pour-over and the trust is 16 pages. You can just imagine that a testamentary trust will is just 20 pages because it's everything combined in one document.
Right, right.
The downside with a testamentary trust is that before the gears are even rolling, you have to go through probate. You have to go through the probate process, which can be simple, but not necessarily. And it does, in any event, in all circumstances, tie up your assets while your family deals with the probate court. When you have a pour-over will, by contrast, normally, if you've done a pour-over will, you're working with an estate planning attorney who has helped you title your assets in a way that your trust is already the owner when you pass away, and that pour-over will ends up not even being necessary because that will, again, only applies to assets owned by you personally without some joint owner or other beneficiary designation. So if you use a pour-over will, generally speaking, you've worked with an attorney who has also helped you move everything into trust before you pass away, in which case your family won't have to go through probate at all.
Right. I've got about a minute left here, and you
Hmm.
brought this up one time, and I thought it was excellent. And today with technology, is a video will.
Oh, a video. Yeah, that's interesting. What I prefer, so you can do a video will. You could actually speak your will out loud on a video. I would say in Colorado, don't rely merely on that. Do have a written will that you read aloud on the video, or just have a video taping of your execution of the will document along with your witnesses and notary. So I wouldn't rely on the video will in and of itself. I would still have something in writing. But the good thing there is that especially if you've got a large estate, or no matter the size of your estate, if you're dealing with a potential beneficiary dispute because someone may be unhappy, if the video exists of the actual signing of the documents, it's going to be very difficult for a disgruntled beneficiary to challenge a will on the basis that you didn't know what you were signing or you were under duress when you signed it. So a videotaping of the signing of the will is actually pretty important if you have a situation where there might be a beneficiary who is unhappy. So video wills are getting to be more common, obviously, with kind of, the techie age and all that. But you want to make sure you still have something in writing, because ultimately something that's electronic could somehow get damaged, or, who knows where it could end up and not ever be found.
Okay. And we highly recommend you call Bonnie 303-881-3609 and just sit down with her and, let her work through these things with you, because, it can save so much aggravation, for you, your family, by just having some of these things done. Her website is willsandwellness.com. And again, her number 303-881-3609. So, Bonnie, thank you so much for joining us, and we'll have you back on again. And I hope you have a great weekend.
Thank you, Scott.